Thank you all. Please be seated. This is a time set for oral argument in Dale R. Grabeau versus BMO Harris Bank, our case number CA-CV130164. Each side is allocated 20 minutes for oral argument. Appellant may reserve a portion of that time, sir, if you wish to do so. But if you wish to do so, you need to keep track of your own time at the podium. Out of respect for counsel, I would ask that everyone in attendance make sure that their phone is either turned off or on vibrate so that our presentations are not interrupted. We have reviewed the briefs. We've conferenced the case. We'd encourage you to keep that in mind as you present oral argument to us. Proceedings are being recorded and will be posted in due course on YouTube. So please, as you begin your argument, state your name and the parties or party that you represent. With that, let's start with Mr. McGill.
Thank you. Your Honor, I want to mention at the outset that I'll go 15 minutes and then reserve 5 minutes if I could. So
very well.
I'll try to keep track.
Very well.
I think it's a little after 2:30.
Well, and I'm hoping that you have a timer right there at the podium.
Yes.
Yep.
Thank you. Your Honor, the first exhibits that I wanted to refer to, and the first issue, I think the most important issue in this appeal is the notion that the trial court dismissed the jury trial, the 2-week jury trial, on a standard that we believe was not appropriate under Arizona law. The standard that, with all due respect to the trial court, that was implemented on damages, in particular lost profits damages, was a standard that Judge Fink had indicated that the evidence after a 2-week trial failed to meet, that it was speculative and it was not reasonably certain under the circumstances. And with all due respect to the trial court, Judge Fink also indicated that he was not confident about that ruling. And I know that the judges on the panel have reviewed the materials. In fact, he expressed a lack of confidence about that ruling on March 20th, 2012, which was the last day or two of the trial, on page 161. So I would flag that page as an important page for the panel. And that's where Judge Fink said, and I quote, and he turned to Mr. Goulder and Mr. Palumbo, and he said, "What do I do with this expert opinion, Exhibit 750, which was an expert opinion that we had introduced, and it was read into the record by Gail Barsky, one of the attorneys, co-counsel with myself, during the trial, pursuant to a stipulation." Now, Mr. Goulder tried to.
That's the Powers report. That's
the Mike Powers expert report, yes, which is a 6 to 8 page report that goes through a very detailed table and analysis of the valuations of the lots at the Shea Boulevard portion in Scottsdale, as well as the valuation and cost to build and loans. So in other words, it was equity and cost to build projections. Very detailed.
So
yes.
Right. Those pro formas, they came in, and the jury could have taken them for whatever value they were. But what evidence was there? I mean, the jury could have taken them for as material if the deals had been done. In other words, that report tells us that if these deals had been done, the sequence, the dominoes had fallen in your client's way, then the cost might have been X, the sale price would have been Y, and the profits would have been Z. But what evidence is there that the deals would have been done in the time frame that your client asserted that they needed to be done?
Your Honor, there's two answers to that question. One is, and there's three leading cases on, there's a progeny of cases, there's three leading cases on this particular standard, and that is, the first case is the Felder versus Physiotherapy Associates. That's the Felder case that Judge Fink cited in his ruling in November of 2011, denying the bank's motion for summary judgment on damages that had less evidence in that summary judgment than what we put on at trial. That's my first answer. Judge Fink went through that and cited
real estate case, though.
But let me answer your question directly. Judge Fink, he denied their motion for summary judgment on damages, and he found and set the trial, because they tried to knock us out on this. The case law does not require that the transactions be closed. There only has to be a reasonable basis to claim the damages. That's number one. And that's the Felder case, and that's the Surowick versus Capital Title Agency. It's a 790 F sub second 997. A reasonable basis. It's not a reasonable certainty.
Right.
Just a reasonable basis. And the second answer, Your Honor, to your question, very good question. The second answer to your question is, in the Felder case, which is a Major League Baseball injury, okay, the court in Felder took a page or two and said, he doesn't have to show that he would have made the major leagues but for this injury. He just has to show, he's injured, the fact of an injury, and the jury assesses the evidence. And the Felder case and Surowick go to great pains saying the genius of our jury system is that the jury is more than capable of assessing the evidence that's put before it at a jury trial and determining based on the weight to be given the evidence, the credibility to be given the witnesses, the data in Exhibit 750, Your Honor, and assess the market at the time. The market in 05, 06, and 07, the market did not crash till late 08. So in 05, 06, and 07, the market was so good that BMO Bank was, part of the frauds here was that they were lending to third parties without authorization and without going to Grabaugh, the president, and increasing the amounts at 75% loan to value. So by definition, the bank's underwriting department had determined that they were going to increase the loan amounts through this entire period because of the underlying market conditions, increase the loan amounts to unauthorized parties, not involving Grabaugh. And so they're closing the transaction is an impossible burden. The third and final point on your question, Your Honor, the third point, and this is very important. Both of these cases went to great pains to say that not only can the genius of a jury to assess the credibility and the weight of the evidence and the data in Exhibit 750, and Judge Fink was not comfortable with Exhibit 750, and he asked the attorneys to explain how he could get around that for the Court of Appeals, and he got a non-answer. But the important point in the case is the cases say, if a wrongdoer deprives an innocent bystander or an innocent party of their property, they don't have a right to turn around if they committed a fraud with unauthorized transactions, take a person's property, and then turn around and say, you can't prove you would have closed or sold these transactions after they committed the wrongdoing. That would be extremely anomalous and would reward the tortfeasor. Because all tortfeasors would come into court, they rip off the other party, assuming that happened, and we contend that there were, issues before the jury on the liability portion. But if there's fraud committed, unauthorized transactions, liens that don't have signatures, false notaries, documents with spliced signature, testimony on the stand, I didn't agree to the Lot 54 loan. I never signed a lien on Peoria. I didn't authorize them to pull the deeds out of 55, 56 in Fountain Hills. If this bank, for 3 years, is committing a pattern of wrongful conduct and not going to the person that was the president that signed the loans in the very, very beginning, they went to Grabaugh in 05. That's critical. And then every time they do a loan after that, they go to third parties and send it to a Tempe address instead of Grabaugh's address. They go around them, take the properties with unauthorized transactions, and then turn around and say, you can't prove after you lost your properties that you would have closed on these properties or sold these properties. Your Honor, that's not the law. in Arizona.
Counsel,
that
let
would
me ask
reward the misconduct.
To follow
Thank
up on Judge Johnson's question, which was really what evidence is there that the deals would have been done within the time frame needed, are you saying that we can never look to that, or that there's some relaxed standard, or because here when you have a damages claim that in its sort of most further telescoped view looks at a series of kind of 3 deals, each
Yes.
of which turn on each other.
Right.
Isn't time frame fairly part of the equation?
Well, it is, Your Honor, but the important point from the Surwick case, where the federal court had said that it's well settled in Arizona that it's just a reasonable basis for these damages. You can't have a wrongdoer take your property and then turn around and say you can't prove you would have closed or sold on them. That's what Surwick says. But to get to your point, there was an exchange agreement with Robert McDowell. Dale Grabaugh, on behalf of 51, was in an exchange agreement. McDowell had 24th Street. They set up a complicated exchange. The exchange agreement was in place. That's evidence that's in the record. So they had an exchange in place that Grabaugh could not, on behalf of 51, he could not fulfill this exchange that had synergy and leverage in a real estate transaction that had a $3 million equity position that was in place. You're asking about evidence. Signed, in place, with a pro forma from McDowell, which is also in the record. It's Exhibit 348.
But doesn't the force of that turn on the ability to then sell those units or rent them, depending on whether it was a condominium or apartment, at a price and at a time that would reveal a profit and allow then for the third phase to move forward? And isn't that, and it's a compound question, Counsel, but isn't looking at that timing a fair thing for a trial court to determine?
Well, it's within the province of the jury, and that's what Judge Fink had ruled in the earlier ruling when he denied their summary judgment. He actually quoted from Felder, and what he quoted was, there's sufficient evidence in this record. This was in November of 11, 6 months, a few months before the trial.
Let me interrupt you, because I understand there was pretrial motion practice, but that's not what we're asked to review.
Well, here's the point. He found in that motion, denying the motion, because what you're suggesting, the questions you're suggesting, with all due respect, Your Honor, is that the judge is just making that determination as a matter of law. Well, he didn't make that as a matter of law when the motion was filed. And the standard on directed verdict is the same as the Rule 56. They're the same under Orm School.
You're not saying, are you, that jurisprudentially he was bound by that ruling?
No, I'm not saying he's bound.
All right.
I'm just providing the concept, the notion that Orm School put the directed verdict on the same standard as a motion for summary judgment. I'm not saying he's bound by it. I agree with you, Your Honor. For example, if we had not put in as much evidence at trial as we did on the summary judgment, he could say, you were better 3 months ago, not today. But we put on more evidence. We put on the testimony of Powers, Grabaugh's testimony. Judge Fink would not allow Grabaugh to testify on the valuation of his own properties and lost profits. And the Kissel case says that the Kissel case, Your Honor, forgive me, the Kissel case, the owner testified about lost profits. So the point is, these cases all say the jury, the judge, the trial court cannot invade the province of the jury. The jury decides after looking at 750, which got in by stipulation. It's got these tables.
We've seen it.
The jury
My question is, did McDowell do the deal without him?
Well,
Without your guy?
they did the exchange agreement.
Oh, did he do the deal with someone else? Did he build the condos?
Well, he had a
with someone else?
foreclosure that was going to happen in another 2 or 3 months. So he couldn't turn around and do a complicated multi-million-dollar transaction in the next 2 or 3 months, Your Honor. No.
Did anyone build any condos on that property?
I don't know the answer to that, Your Honor. I don't know what happened now. But going back to the time frame in question, the jury decides. The judge would not allow Grabaugh to testify about the valuation of his own properties. The judge was concerned about 750 because it's a table of detailed conservative data. And the jury, the cases all say, we should not take an elitist, condescending view of juries. They're more than capable of assessing that Exhibit 750, assessing Grabaugh on the stand if the judge had let him on the valuation of his properties in the equity tables, and determine whether they believe Grabaugh, whether they think that opinion, that expert opinion, is all wet or we think it's legit, whether the exchange agreement is bona fide and legit. And the last point on this, and then I'll stop and reserve 5 minutes, Your Honor. The last point on this is that once the fact of damages is shown, the amount is for the jury. Now, was the fact of damages shown regarding lost profits? The bank loaned at 65 to 75% loan to value and increased the amounts to third parties. They were showing that there's equity by their underwriting. So the jury could have deliberated and said, you know, if there was no equity in these properties, the bank would not have been doing these loans that they're saying were fraudulent and unauthorized. They don't just do loans at 100%, and they testified to that at trial. So a jury can make a reasonable inference. There's equity in these properties. The final point, I'll sit down to get my 5 minutes, Your Honor. The final point is, if Grabat, what they're saying is, he lost all his properties. There's no fact of damage when your entire portfolio that you've worked for 30 years to develop is gone through unauthorized transactions. There's no damage, a fact of damage. The fact that he doesn't have his properties, he's damaged. That is unquestionable that he's damaged because he doesn't have title to his portfolio, and he's got an exchange in place, a $3 million exchange. The issue is, what's the amount? That's up to the jury. That's up to the jury, and Judge Fink was not confident. I'd like to reserve, so I can come back on liability, but damages, I know that's where you want it to be, at least initially.
Thank you, Mr. McGill.
Thank you.
Thank you. Let me look to counsel here. Are you splitting your time, or are you?
Yes, we are, Your Honor. I was intending to go first and take about 12 minutes.
As far as the time allocation, I'll leave it to your better discretion, but
Is
please.
one of you going to talk about one subject matter and the other going to talk about another subject matter?
Yes, Your Honor. I was going to explain that. My name is Jeff Goulder with the Stinson Leonard Street firm here on behalf of BMO Harris Bank and Mitchell McDermott. I'm with co-counsel Scott Malm, also on behalf of BMO Harris. He's with the Gus Rosenfeld firm. The task is for me to deal with all issues except for damages. And I had intended to take 12 minutes or so with that, and then Mr. Egbert would handle the damages issues.
Very well.
So the reason that the trial court judgment should be upheld, quite simply, is there is just no pathway for the appellant to prove that he is entitled to a reversal here. He's not entitled to a reversal here because roughly half of the claim was dismissed on summary judgment motions. Those rulings were all correct. The other half of the case was disposed of on Rule 50 motions. Those rulings were correct. There were other bases upon which the claims could have been dismissed as well, but the trial court never even got there. So I wanted to go through those in a bit more detail. I had intended to cover the facts in about a minute and a half, but I have the impression from the panel that that's not necessary. So I'll just go ahead and dive straight into the merits. The issues that were resolved on summary judgment were the Peoria project and what's called the Lot 54 project. They were both disposed of on the same general theory, which is ratification. There was also summary judgment entered on the 33-420 claim and also on the fair credit reporting claim. I don't believe the fair credit reporting claim is even a part of this appeal at this point. The things that were resolved on Rule 50 motions were all claims brought by Mr. Grosbois personally and his entity Desert Ventures because they had no standing. All claims were disposed of based on damages, and Mr. Egbert will handle the damages part of the argument today. And then also, Judge Fink concluded that there was simply no evidence to support any of the following causes of action. That is, any of the fraud-based causes of action. That was including negligent misrepresentation, common law fraud, and consumer fraud. There was just no evidence to support any of that as against BMO Harris or against Grand Canyon. Judge Fink concluded there was no evidence to support a breach of contract claim. The bank made a contract to loan money and to accept repayment, and that's what it did, and there was no breach of contract. Judge Fink concluded that there was no evidence of an interference with contract claim. And then lastly, he concluded that the quiet title and constructive trust claims should be disposed of because the proper parties had not been joined. That is, the record owners of the properties had never been sued by Mr. McGill's clients. In fact, one of the record owners was one of Mr. McGill's clients, and that is Mr. Yakub. So as far as the issues that have been briefed on appeal, I've compared our issues with Mr. McGill's issues. There is similarity there. We talked about the damages issue that Mr. Egbert will cover. These are the issues I had intended to cover, and that is to explain why the ratification rulings, the summary judgment rulings on Lot 54 in Peoria were correct, why the deficiency ruling on Lot 54 was correct, why the 33-420 ruling was correct, and why the attorney's fees award was proper. In my view, those are the only issues that have been identified by the appellant for discussion today.
I'm interested in the 33-420 issue in particular.
Let me go to the
Not the limitations, but the
33-420
merits.
issue. The 33-420 issue was, the ruling was proper for a number of different reasons. One reason is because the statute of limitations argument that we're now hearing, that is that it's a 4-year limitation period, not a 1-year limitation period, that argument was waived twice by the appellant. It was waived the first time because the argument was never made by the appellant at the trial court. This was an issue resolved on summary judgment. Our argument was it's a 1-year statute of limitations period. Appellant never argued that it was anything other than a 1-year limitations period. His argument was that it was an equitable tolling issue, and the court ruled, I think, quite correctly that it was not an equitable tolling issue. The second time that the appellant waived the 1-year versus 4-year limitation period is when he filed his opening brief. This whole issue, as I'm sure Judge Johnson, you're aware, comes up through the Sitten versus Deutsche Bank case. What I saw from the appellant in his reply brief, because the opening brief says nothing whatsoever about the issue, he says that he was handicapped in his ability to raise the 4-year limitation argument because his notice of appeal was filed before the Sitten case came out. What he doesn't address, of course, is the fact that Sitten was out for 4 months before his opening brief was filed, and that he then filed an amended opening brief 3 months after that. So Sitten was out there. We saw it. We brought it to the court's attention because we were duty-bound to do so. The appellant could have raised that argument at the trial court, should have raised it on appeal, didn't do it, therefore it's been waived twice. Even if Your Honor disagrees with me there, the 33-420 claim still was properly disposed of. And let me explain why. First of all, we have to look at the individual transactions, and I'll try to group them to save time. We've got the Lot 54 transaction and the Peoria transaction. Both of those were disposed of on summary judgment because of ratification. Well, if the appellant has ratified the transaction, then he can't complain about documents that were recorded as a part of that ratified transaction. So there can't be a claim based on either of those transactions. Well, all right, then what's left? That would leave the what we've called the Lot 55 and 56 transactions and the Fountain Hills transaction. Those were the lots that were transferred by Mr. Grosbois' former business associates out of the corporate name into their individual names. And once that transfer occurred, first the lots were transferred and then a loan was put on there and the bank took a deed of trust on those properties. So certainly— Recording
is the deed of trust.
Pardon me?
The recording at issue on those two transactions
yes,
is the deed of trust.
And what I was about to say was there could not be a claim by this appellant as to those deeds of trust because this appellant didn't own the properties at that time. They had been transferred to Mr. Yakub and Mr. Jimenez, Mr. Grosbois' former business associates. So the only transaction that could conceivably give rise to a claim by this appellant on 33-420 would be the transfer of title of those properties from 51 Inc., the corporation, to Jimenez and Yakub personally. And the reason that BMO Harris and Grand Canyon Title can't be liable for those transactions is because they didn't cause them. BMO Harris had nothing to do with that transaction, didn't instruct that it be done, didn't create the deed, didn't record anything. It had no role to play. So for all of those reasons, the waiver issue plus the individual examination of each of the transactions, the 33-420 claim was properly disposed of.
And as to the title company, no demand was made, is the argument.
Well, I believe that is true, and I should have clarified when I started. Mr. Egbert will also handle any arguments unique to the title company, so I'll let him speak to that, but I believe that is an accurate statement. All right. As to the ratification issues, I'll be very quick. Lot 54, the argument was Mr. Grosbois was aware of a loan, approved a loan, but wasn't aware of a later, larger loan. The evidence that was submitted on summary judgment was he wrote draw requests on that second larger loan, and in fact he received account statements on that second larger loan, and we know he received the account statements because he produced them back to us in discovery. So those were the facts on summary judgment regarding the Lot 54 transaction, where Mr. Grosbois said he didn't know about this second larger loan. What he is saying is he didn't authorize it. There has been a fundamental disconnect in this case from the very beginning with respect to ratification. Of course, ratification does not require that the underlying acts were authorized. The very point of ratification is to say even if they weren't authorized, if you've accepted the benefits, then you have adopted the deal, and that's what happened. That's what happened on the Lot 54 transaction. The Peoria transaction is even simpler. Same facts. Mr. Grosbois and 51 Inc. claimed that they didn't know about a loan, yet they took the benefits of the loan, received the loan proceeds, and bought property with the loan proceeds, so they've ratified it. But beyond that, the appeal was not timely with respect to the Peoria transaction because the final judgment, there was a 54B judgment entered February of 2011, and the notice of appeal was filed February 2013. So for that second reason, the Peoria transaction was properly disposed of. The Lot 54 deficiency argument I'll be very quick with. This is a situation where the trial court properly entered a deficiency ruling on behalf of the bank based on the case law that existed at the time. A month after the trial court's ruling, there was a change in the law through a case that came out called M&I Bank versus Mueller. And then just a couple of months ago, a new case came out called BMO Harris Bank versus Wildwood, which reversed Mueller. The entire argument that we've heard from the appellants is based on the Mueller case, which has now been vacated, which is to say the standard isn't whether we actually have a completed house that's utilized as a dwelling. The standard was what was the intention. Well, that's no longer the case. By the way, Judge Fink concluded that even under the Mueller standard, the summary judgment ruling was still appropriate, but we don't need to debate that because the Mueller standard no longer applies based on the Wildwood ruling. And the last thing I'll hit very quickly before I sit is the attorney's fees issue. Again, very simple. The bank is absolutely entitled to fees because of the loan documents that have fee provisions, which we have cited. There was discussion in the briefing about 12-34101 and Barmat and Ramsey AirMed. We don't need to get into that analysis. There's a contractual attorney's fees provision here. So then the only question is, was there additional work done in connection with the tort claims over and above what was needed to dispose of the contract claims? And the answer is no. The same facts underlie all of these claims. All of these claims rise and fall on the notion that these were unauthorized transactions, and we've explained why that is an ill-taken position. With that, I will go ahead and sit. I did want to bring one thing to the attention of the court, though, and that is there was a request for judicial notice filed regarding some recorded documents. There was an order issued that it was under advisement. I have not seen a ruling on it, so I just wanted to flag it to the court's attention. Thank you.
Thank you, Mr. Goulder. Mr. Egbert.
May it please the court, my name is John Egbert. I represent Grand Canyon Title Agency. Let me dive in very quickly into the damage issue. First of all, it's important to note that the issue of whether the extent to which Judge Fink was confident or not with respect to his ruling is a non-issue. This is a de novo review. What's important is whether you're confident or not. And so the issue here is whether or not, what is the standard with respect to future lost profits? Mr. McGill's recitation or assertion that it's the jury's province is just wrong, because it was the jury in the Rancho Pescado case which awarded $2.5 million of lost profits to the individual who said, if you wouldn't have breached the agreement, I could have raised catfish and sold them for a lot of money and made lots of profits. And, just because you put in front of the jury a document that has lots of big numbers on it doesn't mean that you've satisfied the requirement to show that there's sufficient reasonable certainty as to future lost profits. That's what Judge Fink said, and correctly so. The record does not have sufficient evidence of future lost profits in two different separate respects. The first one is akin to, analogous to the Rancho Pescado case. The appellants had to show that they were able to, in essence, Judge, do the deal. They had to be able to show that they could have developed these exchange lots that was going to start this kind of three-level of snowballing of profits. Well, you have to show that you had the wherewithal, the financing available. And we've got testimony from their own damage expert, Michael Powers, that says he admitted he had no idea where plaintiffs were going to get the money needed to build or finish building the homes on the various lots. They had their own witness, Roger Plate, admitted he stopped working on trying to get site plan approval with respect to the 24th, or not 24th Street, the Peoria property, because they couldn't afford to keep paying for that effort. Both Mr. McDowell and the appellants were in a precarious situation, and they hoped that if they could somehow switch properties, that they could make it work. But there's no evidence that they had the financing, the wherewithal to even get to the point of getting enough money to build the houses. But then the second phase of that analysis is to show that even if we could have built them, could we have sold them then for a profit? And we, again, Mr. Powers testified that, contrary to what Mr. McGill asserted here, the evidence that of Mr. Powers' testimony was that the market crashed in 2006. The prices on homes started going down in 2006. There was another one of appellant's witnesses, Steve Thomas, who testified that the real estate recession began in the first half of 2007. But either way, whichever date you want to take, that's the problem. There's no evidence here that suggests that they were going to be able to sell these properties in, by the way, Mr. Powers also said it was going to take at least 6 months to build it if they could get the financing. So now we're into 2008. Where's the evidence that that there was a buyer?
How does, go ahead, Judge.
I'm going to ask about equity.
Very well.
The other theory is lost equity.
Yeah, and Your Honor, I'm sorry, go ahead.
I'm just wondering, following that scenario through, that the transactions were done, the properties were lost, would you have to net off the benefit that the borrower got to not having to repay the loans under that scenario, or does that not work?
I would think that if you're going to accept the idea that there is a lost equity theory here, and I don't accept that, I would submit to the court that this case was litigated from the beginning as a lost profits damage theory only. And it wasn't until Judge Fink then reaches his conclusion that there's no insufficient evidence here, that there's an effort then to say, but hey, we've got these bits and pieces in the record that maybe could be a lost equity kind of a theory. The most important point that I want to make about that is that under the analysis that all you have to do is show the fact, you have evidence of the fact of lost profits, then it can be less certain as to the amount of lost profits. That is a true principle. But it's the fact of lost profits, not the fact of some other theory. So even if there were a legitimate theory of lost equity, that doesn't then satisfy the fact of lost profits. Right. But going back now to your specific question, I apologize for dancing around a bit. In terms of the lost equity, it never was their theory. And the evidence that they have here of simply saying that, for purposes of showing our lost profits, we have this piece of evidence that could be used also for a lost equity isn't enough. I mean, you've got to have you've got to come forward with a theory. And their damage expert said that this was all about lost profits, and that's what Mr. McGill said in the trial, and we cited that portion in our briefs, that it's fundamentally unfair at this point in time to now try to back out and say, well, even if we don't have lost profits, we've got lost equity. But if you do get to lost equity, then I think there has to be that netting out that you alluded to in terms of, well, how were they benefited by the transaction, and not just take all the sweet and ignore the bitter.
Counsel, let me ask, with respect to turning back to your lost profits argument, how do Exhibits 342 and 750 fit into that?
Well, Your Honor, that's analogous to, in the Rancho Pescado case, having somebody come in and saying, here's what my plan, here's my business plan, my pro forma, and I'm going to, if all goes well, my dreams will get realized, this is what I'm going to make off of this. And that's the type of thing you go and you try to get investors, or you get the bank or somebody, but that's not how you prove damage. You've got to at least be able to show that there's a buyer that could have bought these properties sometimes, even if you could have gotten the financing and the wherewithal to build it in the first place. And that's completely missing in this litigation. That's the catfish farmer who's never done it before in his life, and he's now claiming that, look, I got a sheet of paper here that shows lots of big numbers, and the jury apparently bought it. $2.5 million is a lot of catfish, but that wasn't enough as a matter of law. I see my time is out, and I would ask the court to affirm the trial court.
Thank you, Mr. Egbert. Mr. McGill, rebuttal.
Thank you, Your Honor. I'm going to go real quick, if I may, because I don't have a lot of time, and I have a lot of ground to cover, Your Honor. Forgive me. The first thing on the damages is that the catfish case, which is Rancho Pescado, that's a new business, high-risk catfish farm, no competitors, no history, no revenues, no history. This is a person who had a 30 years he developed this. This is a real estate investment portfolio that has leveraging power in a real estate exchange. Totally different than a new high-risk catfish farm, no competitors, no business historical data. Plus, the bank loaned to third parties without authorization at 65% loan to value at increasing amounts. On Lot 54, they had a title commitment of $1,030,000. Ended up at $875 on Lot 54. That's the house. So they're lending at 65% loan to value. So the jury could have been within its rights, based on the evidence, to conclude that Grabaugh had packaged a real estate investment portfolio that had equity and value and leveraging value. The jury could have made that, and the standard is not reasonable certainty, as counsel just said. With all due respect, he's wrong on the cases I cited. It's reasonable basis. And you can't go in and take somebody's portfolio that he assimilated over 20 or 30 years of his real estate investment practice, take his portfolio with unauthorized loans to third parties, and then turn around and say, well, you can't prove you would have done anything with it, so they get to ride off into the sunset? That's what they're telling you. And the cases say you can't do that. Real quick on Mr. Goulder on the liability. He's saying there was no proof of fraud. Let me tick down through it. On Peoria, no signed deed of trust. No signed deed of trust. Statute of frauds.
That's your new motion.
That's a new motion, okay. But it's in the record
but
already.
That's not before,
no,
so.
But Your Honor, it's not just a new motion, because what they did is, after the trial, they submitted with their fee application a notice of lodging judgment, and then magically, because I went back and I looked, magically, and this is in the record. It's in the record. The recorded deed of trust without signatures appeared 2 weeks after the trial with their fee application and a notice of proposed form of judgment. But that was not disclosed through the entire 3.5 years of the litigation. That's in the record. Also, on Peoria, Louis Jakob testified, and if you go to Trial Exhibit 323, if you could make a note of that, Chris Lon, an attorney, was writing Ed Hines on behalf of Louis Jakob. Jakob testified, I talked to Ed Hines on Peoria in the business investment department and told him I'm not the VP of this company. And Hines wrote back, it's Exhibit 323, and said, I understand what you're saying, but we don't agree. So the bank was told by Jakob, who signed on Peoria, that he was not authorized. And they kept going. So how can he tell you today that there was no fraud? On Lot 54, he says that that was ratified, or ratification. Lot 54, because he took a draw or two. Grabaugh had an existing loan on Lot 54, and it was extended. He had an existing loan in the first quarter. In the second half of 06, his loan was extended by the bank at $566,000. The bank is going to third parties to bump the loan to $875,000. Grabaugh testified he was at the bank and the title company and said, get out of my face. Papers dropped to the floor. They almost called the police. He said, I don't want to do this loan. They went ahead and did the loan anyway. After that evidence, at trial. And they never refuted that evidence at trial, ever. And on the 875 ratification, they're saying he took a draw or two in the first quarter of 07. The Gleason case on ratification says you have to have a benefit and you have to have complete knowledge for ratification to kick in. Grabaugh testified, I was taking draws on my existing loan that was extended. I didn't know a draw or two in the first quarter of 07 was from this new loan that I had nothing to do with. The last point, Your Honor.
Clarify.
Sure.
Wasn't it 6 draws? And didn't they?
It was 6 or 7 draws, I think,
right.
Your Honor.
And they didn't 4 of them list the new loan number?
Well, it may have, but Grabaugh testified that when he had over $400,000 left to finish Lot 54, Your Honor. He didn't need the loan bump from 566 to 875, and he told him at the title company and at the bank, I don't need this loan. I don't want this loan. You can't have ratification if the unrefuted trial evidence is in there and he's repudiating the loan and he says, I don't need it, I don't want it. How does that happen, that he gets ratification? So there's no ratification because Grabaugh said, I had an existing loan that I had $400,000 to build this. I didn't need the higher loan. He's not involved in the higher loan. They haven't produced signatures on the higher loan. He's not on the 1003 loan app. Last point, Your Honor. Last point on 55, 56 in Fountain Hills. Gary Howard, our expert, 30 plus years in Phoenix. He's now moved to Washington, D.C. He testified on 55, 56 in Fountain Hills. What they did, here's the fraud they did. Jimenez and Jakob, they took the title from my client's 51 Inc. They removed the title without his authorization and without going to him for a signature. They signed a deed in 07 on 55, 56 in Fountain Hill, purportedly on behalf of 51 Inc., Grabaugh's company, without his authorization, and they knew he was the president, and they deeded it to themselves. And they had an original title commitment, which was Old Republic said, we need authorization from the corporate president to do this. And they were very strict, Old Republic. I gave you the document that Kathy Davidson, on behalf of Grand Canyon Title, wrote on the title commitment, changed the title underwriters from Old Republic, who's giving them a hard time and forcing them to go to Grabaugh that they didn't want to do, change it to Commonwealth, which was easier on the underwriting. Commonwealth, let it go through. Again, no 1003 loan app. Title gets pulled to these 2 third parties individually out of his corporation without his authorization, and he's not on a 1003. They take the money and leave the property encumbered. That's what they did on 55, 56 in Fountain Hills. This case was DV'd on damages. I had substantial evidence of fraud on all of these transactions. Substantial evidence of fraud. No question. Thank you, Your Honor.
Counsel. Counsel, we appreciate your briefs. We appreciate your oral argument today. We will take the matter under advisement. We'll issue a written decision in due course. Thank you all. We stand adjourned.